Hello and welcome to Legally Speaking with me, Tarun Nangia. On the 15th of August 2021, I read an article titled Freedom from Sedition. The article was published by the Hindu newspaper, authored by Dr. Abhinav Chandrachud, a lawyer practicing in the city of Mumbai. And the article explained why the parliamentarians must amend the law of sedition. And it took us back in history about 200 years ago, starting from the law as it existed in the United Kingdom and the law as it existed in British India, and the forms it took all over the years. And we reached today with a certain version of the law, which Dr. Abhinav Chandrachud felt needed amendment by the parliament, and the parliamentarians in their wisdom should amend it. Now, why he wrote this article, what was his intention behind it, why did he take examples from history? We will discuss all of this with Dr. Abhinav Chandrachud today. Mr. Abhinav Chandrachud, thank you so much for joining us today on Legally Speaking with Tarun Nangia.
Thank you for having me on your show.
Now, let us go to the title of your article. It says, Freedom from Sedition. Well, it's a very interesting title. Why freedom from sedition?
Well, when you think of freedom, you naturally think of the colonial period and the freedom struggle. And one of the things that the founding fathers really considered to be a very oppressive part of the colonial period was the Indian Penal Code, in particular the provisions of the Indian Penal Code that were used against many members of the freedom movement. The prince among the sections, in the words of Gandhi, was section 124A of the Indian Penal Code that dealt with sedition. In fact, Gandhi wrote extensively against sedition, and he called it the sword of Damocles hanging over the heads of Indian patriots. So that's why I guess I wrote that title, Freedom from Sedition.
Okay. The article's title also has an introduction. The introduction says, parliamentarians must consider some pressing amendments to the sedition law. And then you go on to say, 74 years after independence, the time has come for all of us to seriously ask whether the law of sedition in India needs to be reconsidered. Very interesting use of words. What are you hinting at?
So, look, my point was when I wrote the article that after 74 years of independence, we now need to take stock of what our criminal provisions are. And many of them are being used to stifle free speech and expression. And the question, therefore, that I have asked myself in the article is that has the time now come for us to reconsider the law of sedition? Of course, one argument is that as the United Kingdom has abolished sedition in 2009, even in India, we can abolish sedition, and section 124A of the Indian Penal Code can be repealed altogether. But to the more moderate people who may argue that, well, we still need sedition on the statute books in the country, what I have suggested is that perhaps we can amend the law to make it, in that sense, a little more conducive to a free environment. And it should no longer represent or resemble what it was in the colonial period. That's really the sum and substance of the argument.
Okay, you provide some very interesting data points. 3.3% sedition cases culminated into a conviction. Point number one. Point number two, the corresponding rate was more than 41% for murder cases and about 22% for cheating cases. So do you, in a sense, want to indicate that the cases that are being filed do not have good enough grounds? In a sense, they are not filed on firm grounds.
Well, that's, of course, whenever you're relying on statistics, you have to be careful. But the statistics in this case from the National Crime Records Bureau seem to suggest that in the vast majority of cases, those cases don't end up with convictions. And when you compare the conviction rate, yes, there isn't a very high conviction rate in the country in many offenses. For example, I believe the conviction rate for cases of cheating was 22%. As you correctly said, the conviction rate for murder cases is 41%. But compare that to sedition, where the conviction rate is 3.3%. That means in the vast majority of cases that were brought for sedition, in the overwhelming majority of those cases, the accused was acquitted of the crime of sedition. So really the question that one must then ask oneself is that why were those cases brought? Was it done so as to set an example? And one of the points that I make in the article and in my book on free speech also is that the existence of these laws on the statute books also has a chilling effect on the right to free speech and expression. This is a phrase that has been used and explained by Justice Nariman in Shreya Singhal's case, where Justice Nariman says that, look, there is an, if I can put it in layman's terms, there is a kind of tendency to self-censor what one says when one knows that there are statutes like this that exist, there are provisions like this that exist. For instance, even if I want to criticize the government, and even if my criticism does not constitute sedition, I may think 10 times before saying anything against the government or any of its leaders if I know that the police might register a false case of sedition against me, knowing fully well that the chances are that I'll eventually be acquitted of the crime of sedition, but that I may be arrested in connection with that crime. The mere fact that I know this, that I may be arrested in connection with a crime of sedition, will have the tendency of making me want to self-censor myself. And therefore, it will have an effect of dampening free speech and expression, or having a chilling effect on free speech and expression.
So you make a very interesting point. The law is so draconian that people say, oh, people in their mind censor themselves before putting anything out. That is a very interesting point. Then in the article, you go on to talk about sedition in England. You say that it was introduced by the colonial government with the intent of discriminating against Indians. But in England, since 1832, you write, seditions had virtually become a dead letter and prosecution was extremely rare. So do you think we are carrying the baggage of colonial law? I mean, at least the first two lines indicate that.
Well, we certainly are, because at the time that sedition was introduced into the Indian Penal Code, it was done in 1870. Very interesting historical footnote. Why was it not done in 1860? Many of your viewers who are lawyers may know that the Indian Penal Code was brought into force in India in 1860. There was no provision that dealt with sedition in 1860. It was brought in 1870. And one of the possible reasons, I argue, is that the Indian Penal Code was being used as a model or a template for a possible English Penal Code in England, because England had the common law. The great codification exercise in India was carried out by utilitarian philosophers who wanted to kind of use India as a laboratory. The colony was used as a laboratory for the metropole. So really the Indian Penal Code would have served as a draft or a template for the English Penal Code. And in England, sedition had become all but a dead letter. Prosecutions were extremely rare. Since 1832, hardly anybody was successfully prosecuted for the crime of sedition. And the definition of sedition was very different from what it was in India. I can talk a little bit more about that, but just to give you some examples, the definition of sedition in England since 1832 was that a person committed the crime of sedition if he or she directly incited their viewers or listeners in order to, in that sense, take up arms against the government, to violently overthrow the government. That was sedition. It was not sedition to merely criticize the government harshly or unfairly. It was not sedition to bring the government into disrepute, or to really say that, well, or to make your viewers not love the government. Absence of affection in England did not amount to sedition. In England, sedition was considered to be a minor offense or a misdemeanor as opposed to a felony. Many of your viewers may be familiar with this terminology from American crime series, a misdemeanor and a felony. A misdemeanor in England was really a crime that entailed a short punishment, 2 years in prison, relatively short compared to what it was under the Indian Penal Code. It was a bailable offense, meaning that if you were arrested in connection with the crime of sedition in England, you had the right to be released on bail immediately. It was non-cognizable, meaning a police officer could not arrest you in connection with the crime, or he could not even investigate the case without obtaining a warrant from a magistrate. And in England, a person had a right to be tried by a jury of his or her peers. So the chances that the jury would convict you were very, very rare, very seldom. It was very seldom that happened, because you were tried by a jury of your peers and the jury verdict had to be unanimous. So even if one person disagreed in the jury, you were considered to have not committed the crime of sedition. This is very different from what sedition was under the Indian Penal Code.
Now, moving ahead, you also said a point where sedition in England since 1932. And you go on to say, only incited violence. If it incited violence against the government, could you be booked for sedition? But even if you criticize the government harshly, you couldn't be booked for it. So now, is this a wisdom of the law enforcement agency that will decide, or does law have any role to play in such an action?
So that's a very interesting question. And, kind of adding to what I said earlier, when sedition was introduced into the Indian Penal Code, it was very different. It looked very different from its avatar in England since 1832. For instance, under the Indian Penal Code in India, sedition was made punishable with transportation for life, as opposed to a 2-year punishment for the misdemeanor of sedition in England. Sedition in India was made a non-bailable offense. In other words, if you were arrested in connection with the crime of sedition, you had to go before a magistrate or the relevant criminal court and ask the court for bail. And the court could, at its discretion, decide to grant you or to refuse bail. You didn't have the right to be released on bail, as you did in the bailable offense of sedition in England. These cases of sedition were very often tried by racially loaded juries. And what I mean by that is that the majority of the members of the jury were white people. They were Britons, so-called Europeans. So you did not have the right in India to be tried by a jury of your peers, because that would have meant that you would be tried by a jury consisting exclusively of Indians. And even a non-unanimous jury verdict in India was sufficient to convict a person of the crime of sedition. So the example that I've given in my article is the example of Bal Gangadhar Tilak, who was convicted by, the first time around, a jury verdict of 6-3, with 6 white jurors voting in favor of convicting him and 3 Indian jurors voting in favor of not convicting him, of acquitting him. And perhaps most interestingly, the definition of sedition in India under the Indian Penal Code, as it was originally introduced, was that even the absence of affection constituted sedition. So sedition meant disaffection. So if I simply made you, as my listener or viewer, love the government less, if I brought the government into disrepute by harshly criticizing the policies of the government, then that constituted sedition. Now, I don't mean, yes, sorry, go ahead.
May I ask you to hold a bit? I'll take you back to Bal Gangadhar Tilak. You made a very interesting point. Bal Gangadhar Tilak was not entitled to get a jury of his peers to innocent hear his matter a case, but which was allowed in England. So this was a law clearly aimed at, in a sense, curbing any criticism of the colonial government. That was the intention of this law, nothing more, nothing less.
You're right to say that. I mean, Bal Gangadhar Tilak's case was a very, very interesting case. Of course, sedition was introduced in 1870. The fear of the colonial legislators at that time was that there'd be a Wahhabi uprising or a Muslim uprising. What happened was that for decades, the provision was hardly ever used. And the first conviction of sedition in India was in 1898 in Tilak's case. Tilak, of course, used to write for a Marathi newspaper called the Kesari, which was published in Pune. And Tilak wrote an article, interestingly enough, during a pandemic. It was the plague pandemic. And Tilak was criticizing the measures that were being taken by the government to eradicate the pandemic of plague. And Tilak wrote an article in which he embodied, or he spoke of Shivaji. And in the article, he wrote that Shivaji wakes up in heaven, Shivaji, the Hindu king Shivaji. And he says that, well, Shivaji is lamenting. What has happened to my country, Shivaji says in the article. I freed my country, and now again, it's being taken over by foreigners. This is what Tilak wrote in his article. And of course, as a result of, or according to the colonial administration, some crimes were committed, some murders took place as a result of this article. And Tilak was hauled up for the crime of sedition. The judge who was delivering the charge to the jury in Tilak's case, a man by the name of Justice Arthur Strachey, delivered a very controversial charge to the jury in which he said that, look, even if Tilak has made his viewers, his readers, love the government less, that constitutes sedition. Absence of affection is sedition. The judge also said something very interesting. He said that, look, Tilak is writing in Marathi. He's not writing in English. So you can't judge this from the standard of what somebody sitting in a drawing room in London or in the yacht club in Bombay, how that person would perceive of the article. So the implicit assumption was that merely because the writing was in Marathi, that Marathi readers are in some way less intelligent than English readers. You can see what the colonial biases were at that point in time. As I told you, with a fractured jury verdict of 6-3 in a racially loaded jury, Tilak was convicted of the crime of sedition and sentenced to 18 months in prison. And that was, of course, only the first time that Tilak was convicted of sedition. In 1908, he'd once again be convicted of sedition by a Parsi judge, a man by the name of Justice Dinshaw Davar, who interestingly was his lawyer in an earlier case. And Justice Davar then sentenced him to many, many years to imprisonment in a foreign prison, to 6 years transportation in Burma, which of course would not have been possible in England, given that it was simply a misdemeanor.
Moving ahead, he says in the article, the framers of India's constitution were understandably suspicious of sedition. Consequently, though the fundamental right to free speech and expression had many exceptions under the new Constitution of Independent India, sedition was not one of them. Then he goes on to say, in Master Tara Singh's case, 1950, the Punjab High Court held that sedition, which is section 124A of the Indian Penal Code, containing the law of sedition, was unconstitutional. So you think we have actually gone to the extent of holding the law unconstitutional and then come back? Why did we come back?
So that too is a very interesting question, and it has a very interesting history attached to it. As I told you earlier, sedition was, of course, one of those offenses that was used extensively against the founding fathers of our country. And therefore, the founding fathers and framers of the Constitution looked upon sedition with a great deal of suspicion. So there was a man by the name of Kanhaiya Lal Munshi, a very influential member of the Constituent Assembly, who moved an amendment to delete sedition as an exception to the right to free speech. And that amendment carried the day. And so sedition was removed as an exception from Article 19(2) of the Constitution. And shortly thereafter, the Punjab and Haryana High Court, as you rightly said in Master Tara Singh's case, found that Section 124A sedition was unconstitutional. But thereafter, once the Constitution came into force in 1950 January, a series of events took place which made our leaders, our political leaders, a little nervous about the extensive right to free speech, or at least supposedly extensive right to free speech that they had given to all Indian citizens. Two cases were decided, I believe, in March 1950 by the Supreme Court. They were the cases of Romesh Thapad and Brij Bhushan. And they were very interesting cases where essentially the sum and substance of what the Supreme Court held was that it is an exception to the right to free speech for someone to say something that may interfere with the security of the state. But a communal riot that takes place in one part of the country will not affect the security of the state. So what the Supreme Court effectively was saying was that if I, as a speaker or as a writer, incite the commission of a communal riot, then that I have the freedom of speech and expression to do so. That's part of my right to freedom of speech and expression, because a communal riot does not affect the security of the state. Now, this is something that disturbed the framers of the Indian Constitution, who were sitting in a provisional parliament at that point in time. Then, that was the first incident, these two decisions of the Supreme Court. Secondly, a very disturbing case, frankly, in a very disturbing judgment, I must say, that was delivered by the Patna High Court, really served as the impetus for the First Amendment to the Constitution. And that was a judgment delivered by Justice Sarju Prasad of the Patna High Court. In one case, in his concluding paragraph in the judgment, Justice Sarju Prasad said, in Shaila Bala Devi's case, that the new right to free speech and expression under the Indian Constitution gives to all Indian citizens the right to preach murder and other cognizable offenses with impunity. This chilling passage in Justice Sarju Prasad's judgment was almost single-handedly responsible for the First Amendment to the Indian Constitution, which came into being in June 1951. That apart, the third reason was that there was a pretty prominent leader called Shama Prasad Mukherjee, who started advocating for the forcible reunification of India and Pakistan, which went against the Nehru-Liaquat Pact. And for these three reasons, the framers of India's constitution decided that they needed to introduce some exceptions, some additional exceptions to the right to free speech and expression. One of those exceptions was public order. So public order was now made a part of the exceptions under Article 19(2) of the Constitution. And it's because of public order that Section 124A of the Indian Penal Code in the form of sedition is now considered to be constitutional. But of course, the Supreme Court of India in Kedarnath Singh's case watered down the charge that was delivered by Justice Arthur Strachey to the jury. And now, today, the definition of sedition in the statute books in India is comparable with what it was in England in 1832. In other words, it is only sedition for a person to incite their viewers or listeners to violently take up arms against the government or to violently overthrow the government. Absence of affection is no longer sedition. It's no longer sedition to harshly, unfairly criticize the government.
Now, moving ahead, if I may ask you, you are saying that repressive features of this law remain. And if I'm not wrong, you just are advocating that these repressive features be in a sense deleted from the law, but the law should remain. What are you finally advocating at? What things need to go in your view and what things can be there on the statute books?
So there are two ways of looking at this, and this is an important question. The first argument is that, look, sedition was used against Indian patriots in the colonial regime. It has no place in an independent country. It was abolished in 2009 formally in England. And since 1832, prosecutions were rare. And therefore, we should repeal sedition. We should repeal Section 124A of the Indian Penal Code. That's one view, and that's an arguable point of view. The other point of view is that, look, sedition in its modified form after Kedarnath Singh's case only punishes very extreme points of view where a person seeks to get his viewers or listeners to really, in that sense, take over the government through violence or through force. Now, if you want to retain sedition on the statute books, I have advocated that 3 changes need to be made to the law. The first is that sedition, the punishment for sedition should be brought in line with what it was in England since 1832. In other words, from life imprisonment, it should be brought down to 2 years imprisonment. Since 1832 in England, the punishment for sedition was 2 years in prison, but in 1870, it was life imprisonment or transportation for life. That remains on the statute books in India today, life imprisonment. The second point is that since 1832 in England, sedition was a bailable offense. In other words, if you were, as I said earlier, if you were arrested in connection with the crime of sedition, you had the right to be immediately released on bail. To this day in India, sedition is a non-bailable offense. So I have advocated, number 2, make it a bailable offense. And the third point, and this is perhaps the most interesting point, sedition in England since 1832 was a non-cognizable offense. In other words, the police could not arrest you, the police could not investigate the case without a warrant from a magistrate. Now, even in the colonial period, even under the Indian Penal Code since 1870 onwards, sedition in India was a non-cognizable offense. So Bal Gangadhar Tilak could not be arrested in connection with the crime of sedition unless the police obtained a warrant from a magistrate. But in 1974, when Indira Gandhi's government enacted the new Code of Criminal Procedure, which supplanted the Code of Criminal Procedure of 1898, for the first time in the history of the country, sedition was made a cognizable offense, which means that if any person today is accused of the crime of sedition, the police can arrest that person without even obtaining a warrant from a magistrate, which was not even the position in the colonial period. So we've actually gone back.
This precisely what you say has a chilling effect on freedom of speech. One last question, Dr. Chandrachud. When you speak of Bal Gangadhar Tilak and him writing an article, earlier prosecutions under the sedition law would have been rare because you should have had the eminence to become a columnist in a newspaper or have the opportunity, in a sense, to speak out things where you actually have an audience of people. But with Twitter, Facebook, and so many social media, any boy sitting in any town, any girl can write anything. And we have seen that even these people get booked who would have written it in a spurt of innocence or some emotion. They don't know the impact it will have because the law is such. Do you think the lawmakers have to take this into account, that India is a very young country of millions of students and millions passing out every year? And you go through those phases where you're very vocal, when you're in college, when you're a young, in a sense, in your youth. And that has to be taken into account when we amend the law. Do you think that maturity needs to come in the discourse in our society?
So I don't think that the members of India's parliament or of course the courts will look at it from the point of view of the age of the person who is, that's an interesting question. I don't know, statistically speaking, whether those who are accused of the crime of sedition are typically younger or older. That's something that needs to be looked into. But I think the definition of sedition and these measures that I've advocated for making it perhaps less repressive, I think these can be introduced, regardless of what the age of the person is who is accused of the crime of sedition. I don't think we should tie proposals for modification, for amendment or reform with what the age is of the accused person.
No, I'm not asking that. What I meant to ask is that our social milieu has changed. Earlier, only a few had the opportunity to say something. Now, everyone has a platform. My tweet on Twitter may get millions of views. But earlier, I never had that platform because not everybody had access to media. Only few people could write for a newspaper or give speeches. Do you think that has changed in our society greatly with the explosion of social media in past 5-7 years?
Right. So merely because now today everyone has a microphone, I see your point that look, earlier only a select few people had the ability to really reach out to a broader audience. Today everyone has the ability to do so on Twitter or other forms of social media, whatever it may be. But to that, I would say that merely because everyone has a microphone doesn't mean that we have to have repressive laws on our statute books in the country today. And the example I always like to give is a test that was formulated in the US by a judge by the name of Oliver Wendell Holmes, who said that the most stringent protection of free speech will not protect a person who falsely shouts fire in a crowded theater. And the reason I like to give this example is that it's only the person who falsely shouts fire in a crowded theater who should be prosecuted and penalized. And that's because you can't argue with the person who shouts fire in a crowded theater. When that person shouts fire, knowing that there is no fire, by his or her words, that person immediately induces a panic. But so long as there is room for debate, if it's possible for a person to debate with another person, to reason with another person, then I think that we should not prosecute that person. We should leave it open to debate and discussion. I believe it was Justice Brandeis who said that if somebody says something that's wrong, the answer is more speech and not enforced silence.
Yet another final question before we end today's show. Chief Justice of India, Justice N.V. Ramana said he would like to see more discussion and debate in Parliament on laws. Would you echo his sentiment?
So more discussion and debate, of course, would always be the need of the hour. And as lawyers, I can tell you, we derive so much from the Constituent Assembly debates that it would be wonderful, of course, to see how laws that are enacted today are being interpreted by parliamentarians. I believe the law is that only the speech of the mover of a bill can be used to interpret what the provisions of that statute actually mean. But of course, speeches that are made in connection with any bill would naturally shed some light on what those provisions mean. So I think that, of course, is the need of the hour.
Thank you so much, Dr. Abhinav Chandrachud, for sharing your views on the law of sedition. As I'd like to share with our viewers, this is the second episode in the series on law of sedition. The first one was aired last month. And of course, every month you'll see an episode on this issue. It's a very relevant issue for today's times. And as Dr. Chandrachud said, may we see more debate and discussion on laws in this society. And because India has this illustrious history of lawyers being very relevant lawmakers in parliament, some of our lawyers have had great contribution to lawmaking in this country. And as you saw today, Dr. Chandrachud also, in a sense, raised a point that what should be done to the law of seditions. He's put out his views out in the open for all of us to see, in a sense, debate over it and let some good come out of these deliberations. Once again, Dr. Chandrachud, thank you so much for your time. And thank you so much for sharing your views on Legally Speaking with Tarun Nangia. Thank you.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.